Thanks so much for the introduction. Thanks for having me. My name is Mathias Brochhausen. I'm a professor in the College of Medicine at the University of Arkansas for Medical Sciences, and I'm the vice chair of the Department of Biomedical Informatics there. So I'm going to talk today about a representation, an ontological representation for legal entities for biomedicine. I will first say a few things that I don't do. I will not give an entire introduction to the ontology development methods we used. We can discuss those later, but I thought that given the group, it might be better to talk about the actual content of the ontology. I will also not talk a lot about the ontological or the legal theories that are the basis for this work, and I'm more than happy to discuss that too. Today I'm giving a few examples of usage. The ontology we talk about is not restricted to those use cases. It is a very generalizable piece of work that has been generalized in more than these use cases. So without further ado, let me start my presentation. Wait, there we go. So what are legal entities in biomedicine? And I know that there are many that probably came to your mind. I want to walk through a few examples. So when we're hiring medical professionals, both doctors and nurses, we give a rundown of their obligations, and those obligations typically at a later stage will be formed into a contract. So that creates the legal obligation for those people to provide those tasks. Typically, if you onboard in any medical institution, you will sign a truckload of other things that you promise to do. Sometimes for clinical services, this includes following specific guidelines and so on, and the clinical guidelines and so on and so forth. So the process of onboarding a person alone to provide clinical services already comes with a lot of legal obligations and other legal entities surrounding that relationship. In addition, as soon as we talk about research, we also have this side where we have people who have specific roles, like being a faculty member, being an academic teacher, being the advisor to, let's say, a postdoc. And often in those relations, we also create legal or quasi-legal obligations of what we need to do. Then we have grants, of course, and those create reporting obligations, obligations to strive to fulfill what we promised to do in the grant. The people who are getting these grants typically have degrees that they have been awarded, and they have ties to organizations which are often spelled out in legal entities. And then, of course, the legal entity that I hope comes to mind pretty quickly is informed consent. In this sense, I'm more focused on research content, not consent, not clinical consent in what I say today. But of course, clinical consent is also a legal entity relevant in biomedicine. So the participant signs an informed consent template or an informed consent form, and thus bestows certain rights and obligations to either an institution or a person. When we started this work on informed consent, this is what consent ontologies looked like. And this is just a random example of a few classes that exist there. And before I go on, I want to make sure that we all understand that the classes that we see here, or the categories we see here, are not mutually exclusive, right? A signed informed consent form can be both a member of the class signed informed consent form or informed consent form for a clinical study, if it is indeed an informed consent form that is signed for a clinical study. So there were already a few intrinsic problems, but then also at that time, those representations did not come with much axiomatic, that is computer interpretable information. So as far as a computer goes, all of these nice and important and legal and relevant sounding words just are this. They're just strings of symbols. They have no meaning. And I mean, we got, I think, from the previous presentation that to build a semantic infrastructure we need ways to also relay aspects of meaning. And so at the time we started this work, which was around 2012, there was no ontology around that provided any insight in that. It was very form-driven, and you can see that as soon as you would want to do a tiered consent, you would be pretty much on your own. So the use case we had actually comes from our work in biobanking, the ontology for biobanking, which I'm still involved with. And the use case we had is, how can we find lung tissue that is stored at a cryogenic temperature with which I can conduct genomic studies? And you see that at least if you have a tiered kind of approach to consent, this would be really hard with just having an ontology that is merely just a box of drawers where you put your form in. So in order to enable this use case, we actually needed to move forward developing the informed consent ontology to cover these use cases. And the informed consent ontology is another OBO Foundry ontology that we worked with a lot during that time, and that really grew into a good resource for this. So it's important to note it's not enough to track informed consent documents, right? Because that'll be, in the end, not helpful in addressing the use case. What we need to be able to is we need to represent and track the rights and obligations related to each specific informed consent form, and of course also who these rights and obligations were bestowed to, and whether there are restrictions to those. In order to do so, we need a theory of how, or at the time we needed a theory of how rights and obligations that are related to the informed consent process are to be represented. So, and this is how we viewed things at that time and how we still view things. And I will explain some of the more hermetic language on this slide as we go along. So when John Doe signs an informed consent form, this has a specific outcome, and that outcome is John Doe's role to be able to claim that the obligations that were created for the institution that he granted consent to went into, and that institutions, in the case of that slide, it's my home university, UAMS, duty hold a role to honor those obligations. So this is all founded on work by Barry Smith that happened around the time of 2012. At the time when we started, this was fairly new. The way that we phrased this is a declaration. Declarations can be made verbally or written, and what we wanted to represent specifically is written situations of consent. When we come to withdrawal of consent, that can often be done in a verbal way. So there we don't need a document act, but by and large, for granting consent, we always need documents involved that are signed and so on and so forth. The idea of a document act was born in more a theory of economics and law rather than in a clinical setting. But I think we can go beyond Smith's definition of document acts, and we can say that these deontic document acts that we saw in the slide before, where John Doe signed an informed consent document, are not restricted to economic entities. And they are based on a theory that some social acts bring about legal or quasi-legal entities, and those we call deontic declarations. That is the deontic declarations then are cited by the Deontic Document Act. Document acts are things where we use documents to not document something, but to actually do something. So if we sign it, we stamp it, or we publish it, and thus something turns into law or becomes effective in legal terms, then we have a document act, which is clearly the case for signing an informed consent form. Okay, this is just bringing this slide back up to remind everyone we're now switched talking about deontic declarations, and we have ascertained that John Doe signing an informed consent form is actually a deontic document act. Yeah, I said that before. All rights and obligations are brought about by some social acts, and some of those social acts are document acts. For the purpose of this talk, we do not need to go into much detail about rights and obligations that are not created by document acts. Again, one example is retracting from a clinical trial is typically, you are able to do that verbatim without going into this. So this is spelling all that happens out before. So the actual act of consenting is part of the informed consent process. You typically have an input document, something that I called a template before in the previous slide, that is signed, and that now creates the actual consent. So all of this, so to speak, ontological representation that is needed for this is in existence. It's in the Document Act Ontology, which can be found at the link that I specify here. There's a GitHub homepage for it, and the effects of using DActs here is based now that we have, we can specify that rights and obligations that are created once the forms are signed. We can now represent different tiers of consent for each consent process and say what a person consented to, who has the right to do specific research with that, to represent restrictions to those rights where applicable, and so on. And once that is done and we use that consistently, we will be able to query biospecimens, for example, and find out what are the rights and obligations and the restrictions that apply to those specimens. Similarly, for any kind of study participant. Yeah, and I said that we can also expand that beyond informed consent to protocols or data use agreements, something that we are doing right now. So since I still have some time left, I want to move things to the other example where we talked in the beginning about legal entities that are created by professional roles or institutional roles, where people are onboarded as, say, a surgeon in a specific hospital, and that creates obligations for them. It also creates claims for them. Once I sign a labor contract as a surgeon, I can expect to be remunerated accordingly. So, and we use this part of Document Acts, and the ability to represent that in Document Acts in an NIH-funded project, which is now is now renewed. In the first phase, it was called CAFE. We've rebranded it now as Tiptoe, and the goals of this are really to find out or give some pointers why patient outcomes in level 1 and level 2 trauma centers are surprisingly variable, given that those organizations have basically the same clinical specialties and services. I mean, the difference between a level 1 and a level 2 is that the level 1 is an academic medical center, but all of the other components of those centers are greatly the same, but even within only level 1. So if you said, well, maybe there's some magic happening because it's academic, but even if you compare only level 1s and only level 2 traumas centers amongst each other, the outcomes are still highly variable. And some reasons for that are obviously have to do with location, where those centers are, what type of injuries come in. But we are working under the hypothesis that there is also, there are micro-organizational structures that go into how successful those institutions are to provide patient care. And we're going to test which organizational features contribute to this variability. And our aim is to recruit 230 level 1 and level 2 trauma centers across the US to onboard in this study. And we will research also which organizational characteristics are indicative of institutional commitment to trauma care. And then in the process of the whole thing, we will share the results, especially of the first part, with the participating centers in a way that informs the stakeholders there quickly to engage and motivate organizational changes were necessary. And in order to do all this work, this is again NIH-funded project. The current consortium includes the University of Arkansas for Medical Sciences and the University of Florida, and the project end date is in 2026. So the competency questions we are concerned here is, what are the obligations of a trauma medical director? What are the privileges of a trauma program manager? And does the trauma medical director have the authority to staff the trauma panel? And the language in the slides already hints to the fact that we might need more than just the deontic roles that we have. For once, we also need to represent institutional roles, the role of a physician, the role of a surgeon, the trauma medical director role. Those all exist in a specific ontology created for trauma care called OOST, which is part of this project. But we also need the deontic roles, like the medical director's authority. What we also learned is we need extensions to go beyond just representing claims and obligations, because we now have things like Dr. Doe's OR privileges, or Dr. Bo's power to revoke Dr. Doe's OR privileges, and my immunity against some change of employee status that is created by tenure. Like, I mean, I'm immune to some changes based on tenure. So this showed us, like a few years back, that we needed to extend the original way we represent rights and obligations. And we went back to look further into legal theory, and this is the outcome of it. Yeah, I don't want, these are the legal theory specifics. I don't want to go over those necessarily. And I think we have a little more than 5 minutes left for discussion. If you have any interest in either using biobanks and ontologies, we're already talking to a group in the NCI about this, or if you have an interest in using DActs and need some pointers, please don't hesitate to be in touch. I'm also a member of many other ontologies we are creating, like, for example, the one for the trauma care project. So if you have any need for a clinical or clinical research ontology and you find my name, don't hesitate to be in touch. The work that I presented today was partially funded by the NIGMS under the Cafe Now Tiptoe, sorry, this is an old slide, grant, but the grant number is still accurate. So thank you very much, and I'm happy to take your questions.